Now, over in the Department of Justice, we have the Drug Enforcement Administration, and they deal with scheduling. And scheduling determines the level of regulation a substance is accorded under the law. We've heard many speakers in the last 2 days make reference to marijuana's Schedule I classification and how difficult that makes research. Scheduling determines the constraints, the regulatory constraints. Now, for example, Schedule I can only be used for research and only under the tightest security provisions. So you have to have safes, you have to have fences, you have to have elaborate security if indeed you're going to be producing it. If marijuana, for example, were a Schedule III drug, it would be a lot easier to conduct research because you wouldn't have as tight of controls over it. So the relevance of scheduling is that it defines the regulatory environment. And the regulatory environment, in turn, helps establish the economics. It determines the capital flows. It determines the return on investment that someone might make trying to invest in medical marijuana. I'll return to this a little bit later. But that's what the importance of scheduling is. It is not determining whether or not marijuana is a safe and effective medicine. It is determining the appropriate regulatory mechanism for handling marijuana should anything else happen with it, whether it be FDA approval or experimental programs or what have you. Now, when talking about rescheduling, you talk about a petition. It's not a petition that everybody signs, although public support is more than welcome. It's really a legal document that states the case. It lays out the evidence, and then the government has to review that. Now, there have been 3 rescheduling petitions, and I've been associated with all of them. The first one was filed in May 1972 by the National Organization for the Reform of Marijuana Laws. That petition took 22 years to make its way through all the federal regulatory processes, mainly because the government didn't want to do anything on it, and NORML and their allies had to go to federal court several times. There were several court decisions. They're listed in the handout. Finally, though, the NORML petition, let's see, in the 70s they were fighting in federal court. In the early 1980s, they were fighting over to get a official evaluation of the petition by HHS. Finally, they had a hearing before Judge Young, Judge Francis Young. It's been talked about quite a bit. And then eventually, NORML's petition died in federal court. And I'll shed some more light on that shortly. The second petition I filed myself with the backing of High Times Magazine in 1995. High Times Magazine I've been associated with in one form or another for over 20 years. They've been a strong supporter of NORML, and they have guaranteed legal representation for my 1995 petition, and they have renewed that commitment to provide legal representation for the current petition. So I filed a petition in 1995. Didn't take 22 years to resolve, but we ran into a problem in federal court in which I wasn't sufficiently injured enough to have standing to take the issue to federal court. So we've done this all over again, and in 2002, we organized a third petition, and that one is now pending before DEA. And I'm going to tell you in the course of my remarks a little bit about the strategy of that petition and what its status is. But to really understand and appreciate this process, I need to tell you a little bit about the laws that govern this process. Now, in the handout, I have a list of what the actual steps in this process is. But the interesting thing is the U.S. Code, is where the rules are. And the Controlled Substances Act is Title 21, Chapter 13, Subchapter 1, Part B is where we're going. And there's 2 important sections here, Section 811, Section 812. You don't need to know this, you won't be tested on it. But Section 811 lays out the process. Someone files a petition. DEA verifies that it has new information. They refer it to HHS for a full and complete scientific and medical evaluation. That evaluation then is binding on DEA with respect to scientific and medical issues. And then after DEA gets that evaluation, they do their own evaluation and they issue their recommendations. People who have differences with them on issues of fact can call for a hearing before an administrative law judge, like the ones before Judge Young. Or if you have issues of law, you can go straight to federal court. Now, the real fascinating aspect of the code, though, is in 21 U.S.C. 811C, which lists 8 factors determinative of control or removal from the schedules. Now, most people, when they talk about rescheduling, they talk about 3 very important issues with marijuana. They talk about accepted medical use in the United States. They talk about the abuse potential of the drug. They talk about whether or not it is safe for use under medical supervision. These are all very important findings that need to be determined during the HHS scientific review. But how are those findings supposed to be arrived at? Well, that's what's in 811C. They list 8 factors. And so, for example, the last 2 petitions I've helped put together, we have taken each of those 8 factors and come up with a great deal of relevant scientific information, much of which has been generated by the scientists reporting at this conference and their colleagues as part of this great scientific revolution on cannabinoids. Now, these 8 factors include such things as the actual or relative potential for abuse, scientific evidence on the pharmacological effects of the drug, the state of current scientific knowledge, the history and current pattern of abuse, the scope, duration, and significance of abuse, what, if any, risk there is to public health, the psychic or psychological dependence, and then whether or not the drug is a precursor of other substances. That's a little technical one. It's not quite as important here. When one looks at the legislative history of this statute, each of these 8 factors is explained a little bit more. And the one that is on the history and current pattern of abuse, it says you really got to do a cost-benefit analysis of any scheduling decisions you want to make, because you want to make sure there aren't any adverse impacts on important populations. And in the legislative history, it adds especially the young, because when this legislation was put together, marijuana was very much in the forefront of Congress's consciousness, if you will. And indeed, in the legislative history, there are 2 fascinating things. One, there is a table of it's a presentation from the National Institute of Mental Health from a Dr. Yoles, and it lists facts, myths and facts about cannabis. And it sort of shows the state of knowledge at that time in 1970. But also buried in the legislative history is, and the citation is in the handout, there is a letter from the Assistant Secretary of Health at that time, Roger Egbert. And I'm going to read you part of this letter, actually most of it. It's very short. It says, this is 1972. 1970, excuse me. Quote, some question has been raised whether the use of the plant itself produces severe psychological or physical dependence as required by a Schedule I or even a Schedule II criterion. Since there is still a considerable void in our knowledge of the plant and effects of the active drug contained in it, our recommendation is that marijuana be retained in Schedule I at least until the completion of certain studies now underway to resolve the issue. If those studies make it appropriate for the Attorney General to change the placement of marijuana to a different schedule, he may do so in accordance with the authority provided in the bill. Now, that was 1970. Those current studies underway ended up being the National Commission on Marijuana and Drug Abuse, which, also known as the Nixon Commission, subsequently recommended decrim, among other recommendations. But even at that time in 1970, they knew that marijuana most likely did not fit the criteria for Schedule I or Schedule II. So the question is, how do we pull it out of there?